Consider a city that chooses not to fully cooperate with federal immigration authorities. This is the essence of a sanctuary city. It is a term without a precise legal definition. However, it shapes local policies across the nation. Jurisdictions adopt these policies based on local political coalitions and demographic factors, not on crime rates. Proponents argue these policies build trust within immigrant communities. This makes residents feel safer reporting crimes and accessing vital services. Opponents, however, contend that such policies undermine the rule of law, raise public safety concerns, and potentially strain local resources. Sanctuary policies often restrict local police or city employees from questioning residents about immigration status. They also refuse federal requests to detain individuals beyond their local release date. This is especially true if the person faces only minor local infractions. Interestingly, research indicates that sanctuary policies either have no effect on crime, or they correlate with lower crime rates and stronger local economies. A Washington Post report highlights decades of research. This research shows that immigrants, both legal and undocumented, tend to have lower crime rates overall. This challenges common criticisms, reinforcing the idea that these policies foster community safety and economic vitality. The modern sanctuary movement in the United States traces its origins to the early 1980s. It is deeply rooted in religious philosophy and resistance to perceived state injustices. Central American refugees fleeing politically unstable countries like El Salvador and Guatemala sought asylum. Tens of thousands of people perished in civil wars there. Faith-based groups in the U.S. Southwest led the charge. In March of 1982, 8 churches publicly declared themselves sanctuaries. John Fife, a minister and movement leader, famously informed Attorney General William Smith. He said his church would openly violate the Immigration and Nationality Act by providing sanctuary. San Francisco marked a key milestone in 1985. This was with its symbolic City of Refuge resolution. It prohibited city funds and resources from assisting federal immigration enforcement. The language used to describe immigrants has evolved significantly over time. The term alien, once common in news reports, has sharply declined due to its derogatory and dehumanizing connotations. Major news outlets like the Associated Press and the New York Times revised their style guides. They advised against using the term illegal when referring to people. Instead, they preferred terms like undocumented immigrant or unauthorized immigrant. This shift reflects a broader societal change, focusing on actions rather than labeling individuals. The U.S. Citizenship Act of 2021, proposed by President Joe Biden, further aims to remove alien from federal immigration laws. It would replace it with non-citizen. The federal government engages in a persistent tug-of-war with sanctuary jurisdictions. During the Trump administration, a pledge to strip federal funding from sanctuary cities became a central theme. President Trump often characterized these jurisdictions as threats. He claimed they served as best friends of gangs and cartels. His administration launched lawsuits, including one against the state of California. They argued that state laws made it impossible for federal immigration officials to do their jobs. However, federal courts often pushed back. A judge in San Francisco, for instance, issued a nationwide injunction against attempts to withhold federal funding. He cited constitutional violations regarding separation of powers and states' rights. These legal battles highlight a fundamental dispute over jurisdiction and federal authority versus local autonomy. California has taken a strong stance, enacting Senate Bill 54 in October of 2017. This effectively made it a sanctuary state. This law prohibits local and state agencies from cooperating with immigration and customs enforcement regarding undocumented immigrants. This applies if they have committed only misdemeanors. This legislation emerged from a landscape where 7 of the 10 states with the largest unauthorized immigrant populations either have statewide sanctuary laws or contain major sanctuary cities. Los Angeles, in particular, boasts a long history of limiting cooperation with federal immigration. In 1979, the city adopted Special Order 40. This barred LAPD officers from inquiring about immigration status solely to determine it. In 2024, the city went further. It adopted an ordinance prohibiting city resources from being used in immigration enforcement unless mandated by state law. This reflects a deep-seated local commitment to fostering community trust. A critical part of this intricate immigration landscape is deferred action for childhood arrivals, or DSCA. This policy was announced by President Barack Obama in 2012. It offers a renewable 2-year period of deferred action from deportation. It also provides eligibility for work permits for individuals brought to the U.S. as children. It emerged after Congress failed to pass the DREAM Act, which would have provided a path to permanent residency. DSCA, while not a pathway to citizenship, prevents enforcement attention from low-priority individuals. These are individuals who have largely grown up in the United States. To qualify, recipients must have arrived before age 16. They must have lived continuously in the U.S. since 2007 and have no serious criminal record. A vast majority of DSCA recipients, around 80%, come from Mexico. California and Texas host the largest numbers. The impact of DSCA is significant. Research indicates it boosts wages and employment for eligible immigrants. It moves tens of thousands into formal employment and reduces poverty in undocumented households. Beyond economic benefits, DSCA improves mental health outcomes for recipients and their children. This eases the stress of uncertain legal status. Economists largely agree that DSCA benefits the U.S. economy. They reject claims that it displaces native-born workers. Ending the program, some analysts warn, would lead to substantial economic losses. It could potentially reduce U.S. GDP by hundreds of billions over a decade. These findings underscore DSCA recipients' contributions to the economy and society. The legal battle over DSCA remains intense. The Trump administration attempted to rescind DSCA in 2017. They argued it was unconstitutional and harmed the economy. This sparked numerous lawsuits from states and organizations. In 2020, the Supreme Court ruled against the Trump administration's rescission. They found the stated reasons inadequate under administrative law. However, the court did not rule on DSCA's constitutionality itself. President Biden reinstated DSCA in 2021. However, a federal judge in Texas, Andrew Hanen, has repeatedly ruled DSCA unlawful. He has blocked new applications while allowing renewals to continue. The case is now before the Fifth Circuit Court of Appeals. Its future is uncertain. This highlights the ongoing tension between executive action, judicial review, and the lives of those caught in the balance. It is important to remember that the concept of a sanctuary city extends beyond North America. European cities draw inspiration from the U.S. movement. However, their definition often differs. In Europe, sanctuary city generally refers to cities committed to supporting legal refugees and asylum seekers, not undocumented immigrants. Over 80 towns and cities across the United Kingdom, for example, adopt policies to foster community connections and support these groups. Glasgow and Swansea are noted for their efforts. This distinction highlights the varied approaches to immigration and humanitarian concerns across different regions of the world, even as the core idea of offering refuge resonates globally.